A very warm greetings and welcome to Law and Life. I'm Shashank Mishra with renowned senior advocate of Supreme Court of India, Subodh Markandeji. In this video, we will be discussing on the bribe for vote by the Legislator, Union of India, please total immunity of MPs and MLA. On 15 November 2022, the Solicitor General of India pleaded before the Constitutional Bench presided over by CGI S. Abdul Nazir not to reconsider the law laid down in the earlier majority decision of the Constitution Bench in PV Narasimha Rao versus CBI. Nothing holds that the Member of Parliament have absolute immunity in the respect of anything said or vote given in the Parliament. Please tell us about PV Narasimha Rao case and the case before the present Constitutional Bench.
We'll have to do this topic at least in two parts. In the
Sure, sir.
first part, we will deal with Narasimha Rao's case. And then in the next episode on Sita Soren versus State of Jharkhand, which is an appeal from the judgment of the High Court of Jharkhand, which is now being heard by the Constitution Bench. So let us look at the brief, undisputed facts of Narasimha Rao's case. In the elections held in 1991, the Indian National Congress, uh, I, had 14 members short of majority. Still, it formed the government. So naturally, on 28th of July 1993, the government faced a motion of no confidence. It managed to survive by 285 votes to 251. One Ravindra Kumar of Bharat Mukti Morcha, a non-government organization doing a lot of PILs in those days, filed a complaint in writing that by a criminal conspiracy hatched by some members of Lok Sabha belonging to Jharkhand Mukti Morcha and Janata Dal Ajit Singh, agreed to receive bribes from Mr. PV Narasimha Rao and others to give votes to defeat the motion of no confidence. So FIR was registered and criminal prosecution was launched by the Central Bureau of Intelligence. Now, CBI so special CBI judge took cognizance against the bribe giving and bribe taking persons punishable under the Prevention of Corruption Act 1988, read with Section 120B of the Indian Penal Code. So the persons who were facing prosecution, they moved the High Court of Delhi to quash the proceedings. Those proceedings were dismissed. So the Supreme Court was moved by the aggrieved parties under Article 136 of the Constitution. Having regard to the importance of the matter, the case was referred to a Constitution bench.
I'm interested to know what are the questions before the Constitutional Bench.
So the following questions were formulated by decision by the Constitution bench. They are paraphrased. They are not in the same. I have paraphrased them. So first question is, does Article 105 of the Constitution confer on the members of Parliament any immunity from prosecution for an offence involving offer or acceptance of bribe? The second question was, is a member of Parliament excluded from the ambit of Prevention of Corruption Act 1988 for any of the following reasons? One, that he cannot be regarded as a public servant within the meaning of Section 2C of the Prevention of Corruption Act 1988. And two, he is not a person comprehended by clauses A, B, and C of of Section 19(1), and there is no authority to grant the prosecution. So these were the two questions which were framed.
So what was the decision of the Constitutional Bench?
The Constitutional Bench, by majority of 3-2, held that Article 105, Clause 2, confers complete immunity on all the members of Parliament who voted. So these two words are to be noted: complete immunity, and for those who voted on the motion of no confidence. One member, Ajit Singh, who did not vote, was not so immune under Article 1052. That is, he did not enjoy the immunity because he did not vote. Others who voted, they came within the definition and purview of Article 105. On the second question, the Constitutional Bench held that a member of parliament is a public servant, because that definition was altered in the Prevention of Corruption Act 1988. And in the earlier act, they were not public servants. So they were public servants within the meaning of Section 2C of the Prevention of Corruption Act. But since there was no sanctioning authority prescribed for prosecution uh, for a member of parliament, he cannot be tried under that act. So these were the two findings.
So what is your critique on of this decision?
So to common men, this appears very strange that a member of parliament who taints his whole conscience in performance of his solemn and sovereign functions of voting in the parliament does not have to face any adverse consequences for such a despicable act. But for us lawyers, there has to be constitutional and legal reasons. So let me formulate. In my view, the immunity envisaged by Article 105 is only for bona fide and official functions of speaking or voting in the House of which he is a member. So if the act is not bona fide, after all, taking bribe is not a bona fide act. And then it is not his official function to take a bribe.
Obvious, sir.
So here the tainted act of taking bribe cannot be and is not an act under the contemplation of Article 105. Article 105 does not contemplate taking of bribe by a member of parliament. Bribery is a criminal offense under several statutes, including the Indian Penal Code and the Prevention of Corruption Act 1988. In fact, the Constitution Bench itself held a member to be a public servant within the meaning of Section 2C of the Prevention of Corruption Act. On this particular aspect, the Constitution Bench judgment of P.V. Narasimha Rao case is not in tune with the earlier decisions of the Supreme Court. In at least three cases which I could find: Satwant Singh versus State of Punjab, 1962 SCR 89, Mata Jog Dubey versus H.S. Bahari, 1955 2 SCR 925, and Amrik Singh versus State of Pepsu, 1955 1 SCR 1302. Now, the immunity is not in respect of what has been done outside the chamber of the House. Immunity is in respect of what is done in the chamber of the House. And it is nobody's case that bribe was taken in the chamber of within the precincts of the House. So there is no immunity for anything done outside the precincts of the House. So On this aspect of the matter, there is a considerable body of decisions on this aspect. So at least two cases I have been able to find. Tej Kiran Jain versus N. Sanjeeva Reddy, 1976 to SCC 272, and Dr. J.C. Ghosh versus H.S. Mukherjee, 1963, 3 SCR 468. Now, I don't want to go into the British and American systems because such immunity is never claimed there nor is held to exist. So, Narasimha Rao's case, therefore, is wrong insofar as these two aspects are concerned. So, it has been rightly, the matter has rightly been referred to five-judge bench. And I think they have rightly decided to consider it. So, I'm not saying that it's a foolproof case, but at least on these two aspects, it's wrong. So, let us discuss about Mrs. Sita Soren's case in the next episode.
Of course, sir. Thank you, sir, for this lecture and